The letter published yesterday by 9 of Britain's most senior retired military officers, including 3 former chiefs of the General Staff and a former head of the RAF, is one of the most extraordinary interventions in modern civil-military relations. Its timing on Armistice Day, or on the eve of Armistice Day, lends it the unmistakable moral weight of experience. The generals accuse Sir Keir Starmer's government of endangering national security through what they call lawfare, the subordination of soldiers to lawyers and a battlefield judgment to courtroom hindsight. Their argument is clear and powerful. They contend that the European Convention on Human Rights, and by extension the UK's own Human Rights Act, have been extended far beyond their original purpose, creating a culture in which British troops, even those acting lawfully under orders, must fear later prosecution. Every British soldier, they write, must consider not only the enemy in front of them, but the lawyer behind them. That image captures their alarm at the paralysis they believe is setting into the armed forces, a legal fog that clouds decision-making, distorts rules of engagement, and corrodes morale. Their specific target is the government's Northern Ireland Troubles Bill, which revives investigations into historic cases from the Troubles, including inactions by British soldiers during Operation Banner. The generals condemn the bill as morally incoherent, claiming it equates those who upheld the peace with those who bombed and murdered in pursuit of political ends. They argue this collapses the essential moral distinction between legitimate authority and illegitimate violence, the line as they see it that defines the rule of law itself. To erase it, they say, weakens the moral authority of the state. Behind their words lies a deeper question. How far should the law follow the soldier into battle? Britain's military operates under the Geneva Conventions and the laws of armed conflict, but since 1998, since the Human Rights Act, those laws have been read alongside the European Convention, which grants rights even to enemy combatants. Cases arising from Iraq and Afghanistan, such as Smith versus the Ministry of Defence in 2013, have held the government liable under human rights law for decisions made in war zones. For the generals, this legal trend transforms military service into perpetual exposure to retrospective judgment. It replaces the ancient covenant between soldier and state that the nation will stand by those who serve it in good faith with uncertainty and mistrust. General Sir Nick Parker puts it bluntly, by reopening investigations there is no genuine safeguard for veterans. It amounts to torture by the state. His warning that Special Forces personnel are resigning in significant numbers underlines their fear that lawfare is not an abstract problem but an operational threat. Elite units trained to act with speed and initiative are being paralysed by legal doubt. Allies, the generals say, are watching uneasily and enemies rubbing their hands. Yet there is another side to this argument. Human rights law exists precisely to prevent abuse by state power, even in times of war. The European Convention was drafted in the shadow of Nuremberg. Its architects, including British lawyers, knew that obedience to orders could not always excuse unlawful acts. To disapply the Convention as the generals propose would set a profound precedent, effectively creating zones of exemption from the rule of law. Critics of the letter argue that no democracy can afford to shield its forces entirely from legal accountability. The line between lawful authority and illegitimate violence is not erased by scrutiny, it is reinforced by it. Sir Keir Starmer, himself a human rights lawyer and former director of public prosecutions, faces a difficult balancing act. He must reassure veterans that the nation honours their service, while upholding Britain's legal obligations under international law. His Attorney General, Lord Hermer KC, has already compared some anti-ECHR rhetoric to the language of authoritarian regimes. But such comparisons will only deepen resentment among those who feel their sacrifice is being doubted or reinterpreted through a political lens. The general's letter should not be dismissed as nostalgia for empire or military exceptionalism. It reflects general unease about the erosion of trust between those who serve and those who govern. The concept of lawfare, the weaponization of legal processes for ideological ends, is not imaginary. It has been used by adversaries and activists alike to challenge state actions in asymmetric warfare. But the answer cannot be to abandon human rights norms altogether. Rather, the government must clarify how these laws apply in combat, perhaps by refining the threshold for jurisdiction or creating a distinct operational legal framework as the generals propose. The poignancy of this intervention arriving on Armistice Day is that it exposes a moral contradiction at the heart of modern Britain. We honour our soldiers by acting with discipline and humanity in war, yet we subject them to laws designed for peace. The generals have thrown down a gauntlet to the Prime Minister: restore the covenant or risk losing the trust of those who defend it. Their warning is grave, that legal uncertainty risks everything, but so too would a system that forgets why law must bind even the powerful. The task before Sir Keir, the task before the Prime Minister, is therefore constitutional as much as military, to reconcile the rule of law within the rule of honour and to ensure that neither is sacrificed in the name of the other.